families, grandparents with canes, children upstairs in Sunday school their parents were blocked from getting to them once this resistance took place, and they had named it Operation Pull-Up. It was heartbreaking for those families. They were terrified. I think they've all said that, and nothing like that should happen in this country.
This may look like a dispute over a protest inside a church, but it's actually a stress test of where constitutional protection ends and federal enforcement begins. What's really being tested here is the boundary between free expression and public order. And who has the authority to define that line when emotions and politics collide? This raises broader questions about how the Department of Justice interprets the First Amendment in real time, and whether enforcement decisions set precedents that extend far beyond a single incident. In this video, we'll break down what this exchange reveals about institutional power, prosecutorial discretion, and the shifting balance between civil liberties and security in America.
Lynn from North Carolina is recognized.
May I have one moment?
You may.
Her district includes Culver City, and she's not talking about any crime in her districts, nothing about helping crime in her district. She's not even worth getting into the details.
Well, thank you, Madam Attorney General, and we are grateful to have you here today. And let me just say that you've shown great perseverance today, and I think you're coming to the last lap here of those of us that are left. But I applaud your strength, and I applaud your resolve. Madam Attorney General, as a pastor for over 37 years now, I take serious issue with any attempts by agitators to disrupt church services or activities at houses of worship. And I just want to take a moment to clarify some things. I realize you can't talk about pending cases per se, but I do want to ask some very general questions for clarification. Does the DOJ consider unauthorized entry into a house of worship to be protected activity under the First Amendment when undertaken by a member of the press?
Unauthorized with the intent of disrupting, yes.
Okay.
Even if it's a blogger like Don Lemon.
Correct. How does the DOJ distinguish between news-gathering activity and expressive or protest conduct when a press defense is asserted?
Congressman, I met with the pastor of that church, and what happened there was horrific. Of course, the press is welcome, and I would hope all houses of worship, whether it's a synagogue, whether it's a church, any house of worship. However, what happened here is a pending case again, but within the four corners of the indictment, they were, quote, gearing up for a resistance. They entered a house of worship, and I think the video speaks for itself. What happened in there, what the video doesn't show, is there were approximately 400 parishioners in there on a Sunday morning, families, grandparents with canes, children upstairs in Sunday school their parents were blocked from getting to them once this resistance took place, and they had named it Operation Pull-Up. It was heartbreaking for those families. They were terrified. I think they've all said that, and nothing like that should happen in this country, and under my watch, it won't.
Thank you. And just to clarify, accosting members of a congregation and creating a scene marked by intimidation and threat inside a house of worship would not be protected First Amendment activity, correct?
Absolutely not, and a grand jury has indicted individuals over that.
Thank you. One other question, just shifting a little bit. You know, my home state of North Carolina has been making national headlines at times, particularly in the city of Charlotte. We've made pleas at times for our governor to get involved, bring in the National Guard. Our Fraternal Order of Police had pointed out that we were about 270 local cops below what we needed in order to adequately police the city. And yet the governor's declined to offer to partner with the federal government to bring in reinforcements to Charlotte. I want to give you just a few moments, really the balance of my time, to explain the impact that Memphis Safe Task Force has had on crime and safety in Memphis, because I know there was a place we saw that cooperation has tended to breed great results, and I would love to hear a little more about that.
Thank you. And I have numbers for you too. Well, and we're all right here in DC, we're all living right here in DC, and I think we've seen the remarkable impact that it has working with members of the Democrat Party on this, with law enforcement, with the mayor, with the police chief, doing everything we can to make DC safe. As of February 9th, there were nearly 10,000 arrests. This is DC. 1,000 illegal guns seized since the operation began, with carjackings down 81% from this time last year, and violent crime down 42%. DC is safer because of it. We know we had a National Guardsman shot, and we had a beautiful young woman killed. I went to her funeral, and I keep in touch with the National Guardsman who was shot, his parents. He's doing great. He's a miracle. Please continue to pray for him. I know my time is up, but same results I spoke about earlier in Memphis, and we're still working on that with the help of Make Memphis Safe Again.
Well, again, I think it just draws an incredible contrast between what we've seen happening in Minneapolis versus what we've seen happen in D.C., what we saw happen in Memphis, and what I would love to see in some ways, if we could ever get our governor to work with us in North Carolina, to happen in Charlotte. But with that, I yield back. Thank you.
Time of the gentleman.
In the final exchange of the hearing, the tone shifted from confrontation to conviction. A member of Congress posed a pointed question to Attorney General Pam Bondi. Does unauthorized entry into a house of worship, carried out under the banner of the press and with the intent to disrupt, qualify as protected activity under the First Amendment? The answer came without hesitation. No, absolutely not. And then came the moment that defined the entire discussion. They entered a house of worship, she said. The video speaks for itself. With those words, Bondi anchored the debate not in rhetoric, but in record. Not in accusation, but in evidence. She described what the footage did not fully capture. Approximately 400 parishioners gathered on a Sunday morning, families seated together, grandparents leaning on canes, children upstairs in Sunday school. And in the midst of that sanctuary, what she characterized as an organized disruption, an action reportedly labeled Operation Pull-Up, allegedly intended to create resistance inside a sacred space. The legal question was precise. The moral question was far broader. What does it mean when the press, protected by one of the Constitution's most revered guarantees, crosses into territory that prosecutors argue becomes intimidation? Where does journalism end and protest begin? And who decides? Bondi was careful. She acknowledged the value of a free press, She made clear that houses of worship, synagogues, churches, any place of faith are not closed to journalists acting within lawful bounds. But she drew a hard line at unauthorized entry combined with intent to disrupt. In her framing, constitutional protections do not grant immunity for conduct that transforms a gathering for prayer into chaos. The congressman pressed further, accosting members of a congregation, creating a scene marked by intimidation inside a house of worship. Would that be protected speech? Again, her answer was direct. No. A grand jury has indicted individuals over that conduct. That statement carries weight, because when a grand jury issues an indictment, it reflects more than political will. It reflects sworn testimony, reviewed evidence, and a determination that probable cause exists. It is a procedural safeguard embedded deep within the American justice system, designed to separate allegation from prosecution. But the hearing did not stop there. It pivoted to a broader theme: cooperation between federal and local authorities. North Carolina, Charlotte, the National Guard, a shortfall of officers, a governor declining federal partnership, the tension between state leadership and federal reinforcements. And Bondi responded with numbers: nearly 10,000 arrests in Washington, D.C., 1,000 illegal firearms seized, carjackings down 81% compared to the previous year, violent crime down 42%. She described cooperation with city leadership with law enforcement across party lines. She spoke of a National Guardsman recovering after being shot, of attending a young woman's funeral, of tangible results when federal and local entities align. In that contrast between resistance to partnership and measurable outcomes, the hearing revealed another fault line in American governance: fragmentation versus coordination. The debate over the prosecution tied to the church incident is not isolated. It sits within a larger national conversation about safety, authority, and the limits of constitutional rights in complex, emotionally charged environments. Critics argue that prosecuting a journalist risks chilling investigative work. Supporters argue that equal application of the law demands consistency regardless of profession. Both positions reflect deeply held principles, and both must be weighed carefully. Because the American system depends on balance. A free press that can question power. A justice system that can enforce law without fear or favoritism. Communities that can worship without disruption. And leaders who must answer publicly for every decision they make. The hearing room became a microcosm of that balance. Lawmakers raising concerns about civil liberties. The Attorney General defending enforcement decisions. Statistics offered as proof of policy effectiveness. Personal stories invoked to humanize numbers. In moments like this, governance is not abstract. It is immediate. It is visible. It unfolds in real time before cameras and constituents. When Bondi said the video speaks for itself, she was asserting confidence in evidence over narrative. Yet in the court of public opinion, evidence and narrative often collide. Citizens will watch that footage and reach different conclusions. Some will see disorder that warranted intervention. Others will see confrontation that deserved restraint. That is the burden of a constitutional republic. Disagreement is inevitable. Scrutiny is constant. Accountability is mandatory. The deeper question is not whether this case will provoke debate. It already has. The deeper question is whether institutions can endure that debate without fracturing. Whether prosecutors can act firmly without appearing partisan. Whether journalists can pursue stories without crossing lines that courts will not tolerate. Whether cooperation between levels of government can transcend political rivalry when public safety is at stake. This hearing was not simply about one indictment. It was about the meaning of boundaries, the boundaries of speech, the boundaries of protest, the boundaries of federal authority, and in the end, it was about trust. Trust that laws are applied evenly, trust that sacred spaces remain respected, trust that statistics reflect genuine progress, not selective framing. Trust that leaders who wield immense power do so with restraint. The American experiment survives on that trust. Without it, every prosecution becomes suspect. Every statistic becomes politicized. Every exchange becomes another brick in a widening divide. As citizens, we are left with responsibility to examine facts, to question narratives, to demand transparency, and to remain vigilant in defense of both liberty and order. The hearing adjourned, the cameras dimmed, but the questions linger. What do we protect first? How do we balance freedom with security? And who ensures that power never eclipses principle? For continuing coverage that follows these questions to their source, beyond the headlines and into the heart of the system, subscribe to Liberty Report USA. Support our work to examine the record, hold institutions accountable, and keep the conversation grounded in facts.